Good morning, viewers. Welcome to Consumer Shorthand classes. Get ready. Five seconds. Gentlemen of the jury, this is a case of some importance. In it arise an unusual number of questions of fact, and it will require the utmost of your good judgment and your care and attention to determine those questions of fact accurately in order that justice may be done between the parties. Those are questions which are exclusively for you to decide. While you will get your instructions with respect to the law entirely from the court, and you need give no consideration to what counsel have said to you about questions of law, the matters of fact are peculiarly and exclusively your province. The suit is brought to recover damages for personal injuries which it is alleged on the part of the plaintiff were caused by negligence on the part of the employees of the defendant company. It appears that on the 16th of December 1899, the plaintiff in this case, a young man in his 22nd year, was a passenger on the car of the defendant company going southward on 6th Street. Just prior to the time of the accident, he was standing on the front platform on the east side of the car, leaning against the brass railing, and as he says, with his hands upon it. At Johnson Avenue, where the tracks of a railroad run and where the track of the defendant crosses that railroad, are a short distance below Johnson's Avenue. He either fell or was thrown or pushed off the car. He fell upon the street. His leg came across the track, and the wheel running against it so injured the leg that later it required 2 amputations. Now it is contended for the plaintiff that this accident was due to negligence. Negligence is a want of due and proper care, such care as a man of ordinary judgment and prudence would exercise under the circumstances of the case. It is to be measured by those circumstances. The plaintiff tells you that the accident occurred in this way. He says that as the car approached Johnson Avenue, it slowed up. The conductor got off of the car on the west side, ran ahead across the tracks on Johnson Avenue, signaled to the car to come along, that the car then crossed the tracks on Johnson Avenue, and that then the conductor jumped on to the front step on the west side, that at this time there were 6 or 7 people standing upon the front platform, that the conductor in jumping on to the step pushed against this set of people arid, that thus he who was on the other side of the platform on the east side was jumped or crushed off into the street. Now, while men are beings who can think and act for themselves individually and may have their individual movements, they are also creatures made up of flesh and bone, and they are just as capable of transmitting momentum as are wood and any other solid body, and supposing the accident to have occurred in the way in which the plaintiff describes, it will be for you to say whether it was the exercise of due and proper care for the conductor, knowing the presence of these people upon the front platform, to so push against them that a possible passenger on the other side might be pushed off into the street. There is one witness who, to some extent, corroborates the plaintiff in his statement about the conduct of the conductor. A man named Johnson, who was coming up 6th Street on the east side below Johnson Avenue, testifies to you that he saw the conductor get on to the front platform. The plaintiff has also testified that the car did not stop on the north side of the Johnson Avenue and that as it went across Johnson's Avenue and down the slope on the other side, it was going at a pretty lively rate. He describes it as nearly at a full rate, and he says that the car, as it crossed the tracks and down to the slope, was swaying to and fro. Mr. Smith testified that the car went across the track very fast, and he describes it as jumping up and down. And Mr. Johnson testifies that when he saw the car, it was jolting. Now there is a further question for you to determine, assuming the truth of this evidence, as to the manner in which the car was going and taking into consideration the situation and the circumstances. There is evidence that this car was full of passengers. There is further evidence that there were passengers upon the rear platform and passengers upon the front platform. There is some evidence that the plaintiff at the time was either sick or in a drunken condition. You will have to determine whether, in view of these facts and in view of the further fact that after the car crossed Johnson Avenue, it approached a downward slope, it was the exercise of due and proper care to run that car in the way in which the plaintiff and his witnesses say it was being run. If you should determine these questions or either of them in such a way as to find that there was negligence in the manner in which the car was managed or in the conduct of the conductor, and should further find that there was no contributory negligence upon the part of the plaintiff, then your duty would be to find a verdict for the plaintiff. In case you do find these questions in favor of the plaintiff, you then will be met with the duty of determining how much your verdict in his favor shall be, and you are called upon to ascertain the damages. What the law looks to is compensation for pecuniary loss which the plaintiff has suffered, and it looks to the compensation alone and no other mode of reimbursement.